Luigi Mangione's health records have become the center of a new battle between his lawyers and New York prosecutors.
Imagine being on trial for your freedom and suddenly learning that the prosecutors may have secretly slipped past the judge to get their hands on your private medical records. That's the fight unfolding right now in the case of Luigi Mangione. According to his defense team, the Manhattan District Attorney's Office faked a court date, drafted a bogus subpoena, and pressured Aetna to hand over Mangione's entire medical file. More than 100 pages of personal health data. If true, that's not just sloppy lawyering, that's misconduct that could undermine the entire prosecution. The DA's office, of course, tells a very different story. They say it was all an innocent mistake, an overproduction by Aetna, compounded when Mangione's own lawyers accidentally resent the same records. Prosecutors claim they never used the files and deleted them after alerting the court. So, which is it, fraud or accident? In this video, we're breaking down what happened, why it matters, and how this courtroom skirmish could reshape the Mangione case. Let's get the basics straight before diving into the subpoena showdown. Luigi Mangione is charged with the targeted and fatal shooting of United Healthcare CEO Brian Thompson outside the Hilton Midtown in Manhattan in December 2024. It was a brazen, premeditated act, authorities say. Mangione allegedly planned the attack, stalked his target, and pursued a chilling message. Shell casings found at the scene bore the words delay, deny, and depose, referencing common criticisms of corporate insurance practices. He's now facing a raft of criminal charges at both state and federal levels, including murder, 1 count of first-degree murder plus additional counts, weapons offenses, and stalking. At the federal level, the death penalty is on the table. You might be wondering, why are medical records even in play here? These medical records are potentially relevant to Mangione's mental state or physical health, factors that defense lawyers often explore in high-stakes criminal trials. That's why the DA's subpoena to Aetna and the way the records were handled became such a flashpoint. The case, which was about murder and motive, is now about whether specific procedural shortcuts by the prosecution may violate privacy protections and due process. The defense's position. Mangione's defense lawyers didn't mince words. In a blistering letter to the court, they accused the Manhattan District Attorney's Office of manufacturing a fake court date, drafting a fraudulent subpoena, and deliberately cutting the judge out of the process. According to them, the DA told Aetna, the insurance giant holding Mangione's records, that if they didn't comply by May 23, 2025, they'd be in contempt of court. Here's the kicker. There was no such court date. The defense calls it a fictitious proceeding, designed to make the subpoena look legitimate, when, in fact, it was never signed off on by a judge. Instead of requiring Aetna to deliver the records to the court, the DA allegedly directed the company to send the files straight to prosecutors. That maneuver, the defense says, wasn't a mistake. It was intentional, and it ensured the DA's office got hold of Mangione's private medical information without judicial oversight. What came back was staggering. About 120 pages of Mangione's complete medical history, what Aetna called its entire designated record set. To the defense, this was not a clerical hiccup. It was a HIPAA violation, federal breach of health privacy, and worse, a constitutional violation of Mangione's right to due process. The defense's letter doesn't just accuse the DA of error, it accuses them of fraud. Words like false, fraudulent, and intentional appear again and again, and they're not stopping at finger-pointing. They've asked the judge for a full evidentiary hearing, a courtroom mini-trial where they can subpoena emails, question witnesses, and drag the details of the subpoena process into daylight. And their requested remedies are dramatic. Recusal of the prosecution team, which would sideline the current DAs from continuing the case. Suppression of any evidence connected to the records. And in the most extreme scenario, outright dismissal of the indictment. Those aren't idle threats. If a court finds prosecutors committed deliberate misconduct, judges have broad powers to sanction them. In rare but real cases, prosecutions have collapsed over less. So the defense narrative is clear. This wasn't a benign error. It was a calculated violation of privacy laws and judicial procedure, one that, if proven, should unravel the case itself. The district attorney's response. After the defense unloaded its accusations, the Manhattan DA's office fired back with a very different story. To them, this wasn't misconduct at all. It was human error, twice. Assistant District Attorney Joel Seidemann, in his written response, flatly rejected the fraud narrative. Mistakes do occur, he admitted. The DA's office says that when they subpoenaed Aetna, they asked for something narrow. Mangione's insurance coverage information and account number, not his diagnoses, not his treatment history, not his entire entire file. According to the DA, it was Aetna that slipped up. The company, they say, erroneously sent us materials that went far beyond what was requested. And when that happened, the DA claims they did the right thing. They immediately forwarded the documents to the judge and deleted their own copy. But here's where it gets even stranger. The prosecution says the defense made the same mistake. At some point in the back and forth, Mangione's own lawyers allegedly resent the same 120 pages of records to the DA's office, compounding Aetna's overproduction. Seidman's letter calls it a double blunder. Like Aetna, the defense then erred, compounding Aetna's mistake. We complied with her request and did not take advantage of her error. And then comes the legal pivot. Even if account numbers and basic coverage data were disclosed, Seidman argued that isn't necessarily protected by HIPAA. He wrote, "The requested information does not appear to be protected by HIPAA, since it did not relate to a condition, treatment, or payment for healthcare. In other words, the subpoena was lawful, the response was overbroad, and the truly private stuff never should have been sent in the first place." That's the prosecution's refrain. No fraud, no scheme, no misconduct, just clerical misfires. And they insist that nothing in those 120 pages was ever used to advance the case against Mangione. To underscore the point, they say they erased the files as soon as the errors were spotted. So where the defense sees a fraudulent subpoena and a deliberate sidestep of the court, the DA sees an honest paperwork accident. One side cries foul play, the other shrugs and says accidents happen. But whether the judge views this as harmless error or a dangerous breach of privacy could determine whether Mangione faces trial as scheduled, or whether the state's case takes a body blow before it even begins. What the judge might do. Now we're at the part of the drama where the spotlight shifts to the judge. The filings are in, the accusations and counter-accusations are on the record, and the court has to decide what comes next. The defense is demanding a full evidentiary hearing. That's basically a mini-trial inside the trial. Subpoenas for emails, testimony from Aetna, and questioning of prosecutors themselves about how these records were requested and handled. If granted, it would drag the subpoena process into open court line by line. So, what are the judge's options? The court could decide this really was a harmless mistake. In that scenario, the records are scrubbed, prosecutors get a stern reminder about HIPAA, and the trial moves forward on schedule. Or the judge could take middle road, suppress any use of the medical records entirely. That would prevent the prosecution from benefiting from Aetna's overproduction, even if the DA insists they never intended to use them. A more serious step would be recusal of the DA's office from the case. That would yank the current prosecutors off the file, forcing another team or even another office to take over. And then there's the nuclear option, dismissal of the indictment. That's rare, but the defense is putting it on the table. If the judge finds deliberate misconduct, fraudulent subpoenas, intentional deception, the court has the authority to throw the case out. Past cases show just how wide the court's discretion is. In some, privacy violations have been brushed off as accidental. In others, judges have slammed prosecutors for cutting corners, issuing sanctions that crippled their cases. So the Mangione proceedings now hang in that balance. One side says fraud, the other says accident, and it's up to the court to decide whether this was a clerical misstep or a fatal flaw in the prosecution. So, where does this leave the Luigi Mangione case? On one side, the defense paints a picture of prosecutors willing to bend the rules. Fraudulent subpoena, a fake court date, and 120 pages of private health records obtained outside the court's oversight. They argue it's misconduct so severe it should cost the DA their case. On the other, the prosecution says it's nothing more than a clerical tangle, overproduced. The defense accidentally repeated the error, and the DA's office did the responsible thing by deleting the files and moving on. Mistakes do occur, they insist, but misconduct this was not. Now it's in the judge's hands. Will this be treated as an innocent stumble or a deliberate breach due process? The answer could determine whether Mangione stands trial for murder, or whether a key part of the case collapses before a jury is ever seated. Thanks for joining us today at Due Process Daily. Throw us a like and consider subscribing to the channel to help us grow.